go when you are ready.
All right, is the petitioner joining us by Zoom?
Yep, Chris is already on Zoom right now.
Yes, I'm ready. Hello.
Hi,
Hi.
great, thank you. So we'll call the meeting to order. First thing we do is determine if a quorum is present, and I note that all members of the board are here. Next item is a review of any possible conflicts of interest or disqualification. In that regard, I filed with the records of the town and sent to the other directors and Max a disclosure on my part dealing with two issues. One is that past chairman of a nonprofit foundation called the Criminal Justice Policy Foundation. And that was the purpose of that foundation was, and I'll just read it, to support the nation's law enforcement effort by research and analysis of areas in which improvement in public safety, law enforcement, and the administration of justice is necessary or desirable. Our research went on from 2012 to about 2021 when we liquidated the organization and distributed the funds to other charitable organizations. Among the activities conducted by the foundation was research concerning the effectiveness of national and state laws regulating the possession, use, and distribution of marijuana. The research was conducted by the executive director. So we provided information to the public, policy matters, and criminal justice professionals through educational programs, conferences, and publications. The evidence that the executive director developed indicated that the then current form and substance of government regulation of marijuana was ineffective in achieving the stated goals of the regulation and resulted in consequences that were not intended by the regulation. So that's the first disclosure point. Second disclosure point is that I'm a Massachusetts lawyer, you know, the state that Maine kicked out, separated from. So my law firm has a practice, a marijuana practice, a cannabis practice. I'm not a cannabis lawyer, I'm a corporate lawyer, but I have helped cannabis company sell itself to another cannabis company. So that's the second one, disclosure. We have reached out to the town council, and she's advised us that she does not see any conflict there. Any reason not for me not to participate, for me not to chair, for me not to vote. But I wanted to present that to you, and then after hearing what you think about it, then to put all that input into the other three members who will vote on whether or not I should recuse myself or not from the meeting. So do you have any comments on that?
That doesn't bother me. I'm fine with your participation.
Right,
yeah.
Thanks. Anyone else have comments? Are there others on the call?
There is Jane Riesenbrock, the select board member.
Any comments?
No comments from me.
Jane?
Oh, that was just spoke.
Oh, okay. Anyone else? No. Leave it to you guys.
If I look at this the same way that I would, consider if you had owned a bed and breakfast, and we were discussing zoning regarding whether a bed and breakfast could be somewhere. I think that many of us probably have had experience. I don't enforce marijuana laws as a prosecutor, but my predecessors did, but I did defend cases in the past. So I just think it's kind of a part of life. I have no issue with it whatsoever. And I believe that you're going to be able to make an objective decision here based on what we're bound to under law. And so no concerns from me.
I'm fine. Yeah, I'm fine too. If anything, I think that your expertise in this area is going to advantage all of us to look at it more fairly and objectively.
All right, thank you very much. Thank you all. So let's go to the next order of business. We'll just go down a checklist here of matters to cover. So in these, when matters come before the board, they must be approved by majority vote. So in this case, it would be 3 out of 4 here would have to approve it. Let's see. When these things come before the board, the appellant has the burden of proof. That means if there's an argument over the facts, dispute over the facts, people seeing facts differently, the appellant has the burden of proving that the information the appellant has is correct as compared to the people who might be saying things that are inconsistent with what the appellant is saying. Do we have in the records, Max, proof of appellants being a Maine registered caregiver? I'm now going on to the standing issues. Okay, great. And do we have like a proof of lease of the premises or?
Yes.
Okay, great. Next matter is jurisdiction. So here, there are only 5 areas that we have jurisdiction. 5 narrow provisions. 4 of them are in the land use ordinance. And 1 of them is in the newly enacted medical marijuana ordinance. So that's all. We can't deal with stuff that's outside that. And that's what's provided by Maine law and by the ordinance itself. We are limited to those areas. So those 4 are in the ordinance, on the land use ordinance, is 5.1.4.1, which I'll just summarize, which is to interpret provisions of the ordinance that are called into question. There are particular provisions in the land use ordinance that are called into question. So we have jurisdiction to interpret that. We also have authority to hear appeals in the administration of the land use ordinance in order to determine if the code enforcement officer or the planning board erred in granting or denying a permit. Again, I'm summarizing it. All of this is in the ordinance, and that's section 514, 5142. The third one is 5143, which is to hear and decide administrative appeals on an appellate basis where it's alleged by an aggrieved party that there's an error in any order, requirement, decision, or determination made by or failure to act by the planning board in the administration of the land use ordinance, and to hear and decide administrative appeals on a de novo basis, which is like right from scratch. I'll look at it all over again, where it's alleged by an aggrieved party that there's an error in any order, requirement, decision, or determination made by or a failure to act by the code enforcement officer in his or her review of an action on a permit application under the land use ordinance. The next one is to hear and decide, and the next one is 5.2.1, to hear and decide appeals where it's alleged that there is an error in any order, requirement, decision, or determination made by or failure to act by the code enforcement officer or the planning board in the administration of the ordinance. The last one is the new ordinance, and that's 4.7 of the medical marijuana ordinance. An appeal from any final decision of the select board or code enforcement officer under this ordinance may be taken by any party to the Board of Appeals within 30 days of the decision pursuant to Article 5 of the land use ordinance. So that's where, if we can decide this matter, that we have to have the authority coming from one or more of those provisions. If this matter does not fall within that authority, we have no authority to make a decision on the matter, and that will be part of what we try to determine as the matter proceeds. The next question, the next topic is whether or not the appeal was timely and the completeness of the application. With the application was, could have, from my perspective, I would have appreciated more information, but it is what it is. On terms of the timing of the appeal, I believe there are 30 days from the action that is being complained about to appealing that action. That's that reference here.
5.4.1.1.
Okay, 5.4.1.1. And we don't have a lot of room there. What we're instructing, and we use, we're just doing the best we can. We use this Maine Municipal Association Board of Appeals manual, and they cite cases and so forth. And so that's what helps us in part make our decisions. I'll just read part of that. The board must also determine as a preliminary matter whether the basic form has been completed properly or whether there's information missing. Then it goes on to say, in the absence of language in an ordinance to the contrary, the Board of Appeals has no authority to change an appeal period. When an appeal is filed late, the board must take a vote as a board at a public meeting of the board, finding that the appellant missed the deadline and denying the application on that basis. So that's just, this is all just introductory points to lay to give you some background before we hear from you.
Okay.
Okay, so let's turn the page here. So I think that's a good segue to having you present your case, and in addition to whatever you've filed in the materials, those will be in the record as anything else has been filed. And I think we'd be interested in hearing your presentation.
Yeah, to be honest, I didn't know how this hearing was structured, or I wasn't even sure I was going to be sort of an active participant. That's why I tried to lay out most of my information in the appeal. But I'll do my best here to summarize, my position, I guess.
That'd be great.
So, I mean, basically, I've been a caregiver here for 7 or 8 years out of Friendship. I've lived in Waldeboro for years in the past. And we heard that Renee Grover was moving out of a location owned by Jeff Hurd, and that there was a possibility we could, open up some sort of a, medical marijuana business there. We talked to Jeff, and we agreed on some terms, and basically tried to figure out how we would be able to operate at the location. And from the get-go, it wasn't very clear about how we could operate. We set up in June or July, and I've always tried to take advantage of everything we could do to make, the business succeed. And we were always, like we were, it's been hard for me to try to determine the line between advertising as a caregiver and advertising that's intertwined with the location. So we had some issues where I was asking Stanley, how to, if this kind of advertising is correct, or can I do window advertising, or, various things. And I met up with him a few times. He would stop by the shop and let us know, hey, this isn't going to work, or, this is acceptable. And I've had, various conversations with Max Johnstone back in June or July, and Mark Desjardins from the Maine Office of Marijuana Policy. And I've tried to walk that line the best I could. Back in June or July, we were told that it was appointment based only. And I spoke to Mark Desjardins at OMP, and he said, walk-in appointments were okay, were acceptable by the state. I checked with Max and asked him if that would be okay, and he said he would check with Mark. He did, and we were told that walk-in appointments would be okay, not just call beforehand, schedule an appointment, then come in and pick up your medication. The way our shop is set up inside, we had a glass case that displayed our various jars of flour and products, and a few menu boards that were left over from Renee. Actually, it was actually Renee's case that was left at the location, and her menu boards, which were left at the location. So we set up our shop in a certain way. As far as somebody could come in, they could look over the products. For the most part, almost all the products were on display. The menu boards were, right there in the main room. You would get checked at the door. The interior of the shop was initially a shared space, so we allowed access to that for the disc golfers to use the bathroom, and we technically only rented 1/3 of the building. So that 1/3, you would need to have your card checked and your ID checked to make sure you were legal with the program before you could come in. But anyway, we were visited various times throughout the fall, in the spring by Stanley to talk about, some questions we had. And we thought everything was going good. And I'm trying to think if I forgot any points here. Like I said, I didn't really prepare. I wasn't aware I was going to be, such an active participant. I thought it was just review the evidence and go down. So I don't have a typed up
Yeah, that's
presentation.
okay. I mean, we've got your information. I just want to make sure that we heard everything that you wanted us to hear. So
Yeah. And most of my points are in my
yeah,
most of my observations and points and my perspectives are in the paperwork. And I had time, hours to write those, write that information down. But basically the issues arose when we were, I was checked by Jim York in, I think it was March. And we were, I'm sorry. Before that, there was one other point. I had tried to figure out what we could do for signage at the location. We were told the green cross is acceptable. And then I had spoken to Stanley, and he said that a sign on the building itself would be acceptable. We figured, especially where the building was only partially rented, so that if there was another tenant that was going to come into the other part of the building, we'd want to show where the entrance is to our area of the building. So I believe it was October, it was either October or November, that I had a sign made up, which said Cider Hill Reserve Medical Marijuana Caregivers Office, with our phone number on it. And we were visited after that was put up several times by Stanley. But anyway, so back to Jim York, OMP, Office of Marijuana Policy. I believe there was a complaint received either by the town or by the state or both, or however that worked. And so Jim York came down to check out the shop and to follow up on this complaint. And at that point, I was told there were quite a few things that constituted a storefront. Now, there's been this, again, this is the line I've been trying to deduce the definitions of how I could operate at the location. There's this so-called entity called an office, which technically exists. It's not. I don't believe that the term office exists in the states. The state's language of the law, or whatever it's called there for the medical marijuana program. From what I can gather, it's sort of just needs to be different than the state's definition of an office. I'm sorry, of a retail storefront. So he told me that that the shop there, he said, this is a retail storefront. He says, there's, you guys, you have a sign on the building, that's basically advertising. He said the way that the shop is set up, the way that there's a glass case and there's menu boards, you come in, you determine your purchase. I was told that is a retail storefront. The way that somebody could walk into the building and, get access to the shop, was basically like a retail storefront. So then, I was like, okay, so he shut us down, and a couple other minor complaints, but I fixed the labeling on some items and got that stuff wrapped up pretty quickly. But then I checked with the town to see, if it was possible to get, what we needed was a written permission from the town to operate as a retail storefront. And I've been confused since the get-go about this whole grandfathering at the location. I was told back in June that I would be allowed to set up there because it was a grandfathered location in the town. I was explicitly told that it's the location that's grandfathered, not the caregiver, because I was trying to figure out exactly how I could operate there. So I assumed, I didn't know if there was if the other two businesses in town, which to my knowledge operated similarly, whether they had written permission as storefronts, or if they didn't, but it was where they were intertwined with supposedly another business there. It got really confusing, and I thought I may have had, permission as a retail storefront, to operate there, but in this restricted way, I guess, in this office way. But anyway, I ended up, talking to Stan, and, was denied the ability to have that written permission from the town. And I guess, this appeal I made the appeal because I feel like we were allowed to operate in several ways, which constitute a retail storefront. And, I invested in the business in such a way that we would be able to operate that way. We had operated for months. Right from the get-go in July, we operated with our interior setup, that Jim York now told us was a retail storefront. We had our outdoor sign up for 4 or 5 months or so, which we've been told by the state is a sign. It's part of a retail storefront. I'm kind of losing my train of thought here. Sorry, go ahead.
So I'll ask some questions. If you have some other thoughts, you can, maybe that'll stimulate some.
Sure.
So the, I want to get now to the, well, let's talk about the grandfathering a little bit, okay?
Sure.
So this is, does not arise, the actions that you described so far here in your materials occurred before the medical marijuana ordinance was enacted. So,
Yeah.
so we're not, since that only covers actions, you can appeal under that for actions either or inaction by the code enforcement officer or the select board for actions taken or failed to have been taken, properly taken under the medical marijuana ordinance. Since what you described, none of that happened since the ordinance, that ordinance was adopted. So I think we can leave that aside. So now I think the actions you're talking about, if they're covered at all, would be covered by the land use ordinance. And so let's go into that part of it. So in the village district, the retail places and the medical offices, however you want to characterize yourself, are governed by the planning board. They're the determining group that governs those. But you said, and so normally you would go to the planning board and make an application. But you were, from what you said, you were told, well, you didn't have to if you're conducting if you wanted to operate under the same application in effect that the previous owner had operated under. That's what you mean. Yeah. Okay.
Yes.
All right. So then you look at what you showed us when you sent the materials in, I think, at that application that the previous owner had submitted and that the planning board assumed, I guess, approved. I didn't see anywhere in there that you could be a storefront. What she was doing, or she was selling beef and other honey and vegetables and things like that in one place. And then she was providing registered caregiving services in a different place with a different entrance, as I understand it. And what she did say in that, as I remember, that they did offer, they proposed to offer, and that they might sell the, what is it called, that oil that doesn't have THC in it.
CBD.
CBD, yeah. So that's anything related to cannabis that she was going to sell in the store part, in the retail part, was TBD, and wasn't, something that you had to that constituted a retail storefront. So, if your grandfather, let's just assume for the moment that your grandfather on the same application she had, then that's the extent to which your grandfather. I don't see any grandfathering in the land use ordinance. It may be in terms of this, of needing to apply for to the planning board, but it may be a practice of the planning board that to save subsequent owners time and expense if they're going to do exactly the same thing that was already permitted by the planning board, that's okay, So I assume that's what happened here. We can assume that for purposes.
Yeah. So if you look at she describes the two different businesses she's going to have at the location.
Right.
There was the retail section up front with her, her meats, her cheeses, her farm products. And I believe she mentioned she was going to sell the CBD there, or possibly there. The second part, which points to the case I'm trying to make, is if you go to if you talk to the state, one definition of a retail storefront are posted hours, among others. These posted hours are described for the medical marijuana caregiver business. In the last paragraph, I believe, they said tentative hours are going to be 11 to 7, which in our experience, my fiance is a patient, and she stopped there numerous times, and those were in fact the hours that the office was supposed to be available, at least in the first first few times she went. But anyway, so that it describes how she was going to have hours for that business, and it may, this whole definition of a retail, storefront, it seems to be, it almost seems to me like it's a little bit different for a cannabis caregiver business than it is maybe another type of business entity. But just having those hours to the state, posting hours, constitutes a retail storefront, at least from what I've been told from Jim York. The other part of that is she had signage at the road for her caregiving business. There's a dual sign. One side of the sign says Barstow Farms, which is the deli farm product retail part of the business. And then the other half of the sign is Rising Sea Wellness, which was the name of her caregiving business. And that was, we took down their sign when we set up shop there, and that sign was at the road. So we looked at that like, that's another aspect of having a retail storefront. So this is kind of the confusion I've been dealing with. We get told some different stuff, like, we can't have a sign or we can't do hours, but then we're told, or I was told, your grandfather at the location, because Renee had a similar, business there. That's why I assume I wasn't made to submit a planning board application.
Yeah, I think though, here's the difficult, and this is a difficult, this is a very practical difficulty. Grandfathering works if she was conducting the business the same way the planning board authorized it. So your grandfather was authorized, if she was not conducting herself the same in accordance with what the planning board approved, that part of it isn't grandfathered. So, and you may have just assumed that she was operating in accordance with what the planning board had approved for her. I don't know. So this is a good example of how to make that distinction. So I just wanted to touch on that.
Sure.
For the grandfathering portion. And then you also mentioned the very serious challenge of when does the town provisions apply and when does the state provisions apply? And then what happens if there's a conflict and so forth? And what's the town's role here?
Yes.
And the town so the town all this time, because there's no ordinance, there's no medical marijuana ordinance, they're operating, if at all, under the land use ordinance, right? If there's any ordinance under which they're operating, that's what they're operating. And if it's it's either a medical office or a retail shop place or something. In any case, it's something that the planning board has jurisdiction in. So if we assume, and we can pursue this further if necessary, but let's just assume for the purpose of discussion that you were authorized to do exactly what she was authorized to do by the planning board. So now the question is, if that's the case, what else? You see, there's nothing else in the land use ordinance that says give a license or issue a permit for either a caregiver, purely caregiver situation, or the retail. Nothing was in the ordinance, in the land use ordinance about that. So what you received from the towns by way of not having to apply was, assuming again, they gave the planning board might be deemed to have given you permission, granted your application to do exactly what she had done. That's in terms of what she was allowed to do, rather what they had authorized her to do in the initial application. So that's as far as that goes. Now, after that, the question is, now what? So I think what you're saying is the now what is that what you're complaining about is this March 31 letter from the town, right? And in which Stan laid out the conditions for your continuing to do business, right? As a medical marijuana caregiver. Because we have to have something we're looking at that says what you're, that's within the scope of what we are authorized to review and see was this proper or not, but I'm just trying to, right, so I heard your, and it's along, there's a lot of issues and complexities in the story. But now we have to say, what is it that what I gathered when what I read and extracted from your documentation was that you had three things in terms of what you were requesting relief from. First was to reverse the decision of Mr. Stanley Waltz, Waldeboro Code Enforcement Officer, in his letter to appellant dated March 31, 2022, regarding the status of appellant's marijuana business. That's this March 31 letter that you signed. All right. Second one is written approval by the town to operate as a medical marijuana caregiver storefront as one of the three grandfathered approved medical marijuana caregiver storefront locations in town. And the other thing I read in your material was that you were asking us to change the decision by the town CEO and for you to be given authorization as a grandfathered medical marijuana caregiver retail storefront at 777 Main Street as one of the three grandfathered locations in town. Is that, you have other, did I summarize those right or state those correctly?
Yeah, basically, although the second and the third seem to be it's all basically just having, I've gone in there under the premise that basically I was grandfathered in as she was, and before the state, put their law into effect in 2018 with the whole, I guess, municipalities opting out automatically thing. She was one of the three businesses before that who were allowed to have what is now called a retail caregiver storefront. So I'm appealing the decision that I was not included as one of those three businesses and asking that I get the permission to operate as she had, which is now defined as a cannabis caregiver retail storefront.
Okay, so when we're using these terms, such as the storefront notion, a retail storefront, so those have like specific definitions.
Yes.
So were you a caregiver retail store, registered dispensary, marijuana testing facility, or manufacturing facility that had been operating with municipal approval in Waldeboro prior to December 13th, 2018?
No, I was not personally.
Okay.
I was, it was insinuated that was the reason I was being allowed to set up there was as, because I was told by Max Johnstone that the location was grandfathered, not the retail, not the caregiver. That changed in April. Then he was, I think he said he talked to a municipal association and that it was the caregiver that was grandfathered, not the location. But that is not what I was initially told.
But I think so let's, again, I want to come back and discuss with you a little bit, Chris, this
Sure.
this grandfathering concept, because it doesn't, if it exists, which I assume it does to some extent, it's not, you can do what was done there before. It means you can do what was, it means what they allowed you to do was not apply to the planning board because permission had already been given in a written specific document that she had proposed and applied to the planning board. And the grandfathering, to the extent it's valid and enforceable, is just to do what it was the planning board permitted her to do. So there's nothing in here that I read that says they authorized her to have a retail marijuana shop, right? I'm just speaking, I'm not trying to use exact terms, but
Yeah. I don't think that term, I believe that term, retail storefront, caregiver retail storefront was after 2018.
Yeah.
Is that correct? I'm fairly certain it was added afterwards. So at that point in time, when she made her planning board application, that kind of business wasn't defined by the state, but the parameters in which she was operating, the tentative hours, or even if she had the deli business up front and the office was only available in the back during the business hours which the deli was open. I've been told that constitutes a storefront because essentially there are hours she's posted with the deli, but that seems like a moot point anyway, because having hours for the caregiver business was part of the planning board proposal. And I'm assuming that that's the only document, like if her planning board application was approved, those propositions for her business operation are like, that's the extent of the accepted, way she can operate that business. Is there another document afterwards that's been like a written list of ways she can operate that I might be missing or I might have not seen, I guess?
I don't know. I don't have that. Or Max or Stan, are you aware of any other?
Changes.
No
It's only
change?
what you read.
Yeah, okay. So as we understand it, there aren't any changes
Okay.
to what we have here.
Yeah, I didn't think so either. I thought it was just the planning board application with what was available. And I just, you see the hours in that application, tentative hours, 11 to 7. And that seems as if it would be part of the approved planning board application she had.
It could be, but in that case, it would be overridden by the state if there was a conflict, right? The state law would say, no, you can't do that. But what she wasn't doing was she wasn't selling cannabis products at retail in that store, in that deli part, right? She was selling meat, and she was selling honey and vegetables and so forth. And then she had another sort of like a spa place where it was a natural healing, and they would teach people how to make various healing products and so forth. And that was, and that's where she had CBD oils, but she wasn't selling cannabis products there. She was only, at least as I understand it, of this application. Okay, so we have that part of it. So the next part is,
Well, she was selling THC medicine at the shop. She said that she wouldn't keep product there overnight that contained THC.
but it was in connection with her caregiving services in a different area. It wasn't retail.
I'm sorry. I
Maybe, I don't know, but she wasn't authorized to do that. She may have done it. I don't know. But
I believe isn't there 3? There's that. I'm not sure what that whole CBD therapy medicine thing was as far as that goes at the location. But there was the third part, which was her having an office, what she called an office where she could meet with her patients and dispense medicine, cannabis for registered patients. So it's kind of like, I'm not sure what that second entity was, what, with this whole CBD, like you were describing, medications and everything. I'm not sure what that was. But it was part of the planning board application, as far as I know, anyway, that she was dispensing, medicine with THC in it to her patient.
Right.
Yeah.
Okay. So now, so you had these discussions back and forth, and you, to me, when I looked at the letter from the town that you signed, it seemed to me that you and the town had reached a written agreement, a contract that said, this is what you do, and if you operate in accordance with this, I think it was going to be okay with the town, basically. That's like a contract. I'm not sure it constitutes a permit. I'm not sure if it's a permit, what it.
Well, the whole thing about that was it was kind of like I've had my business set up, and the state came in, shut me down, And then I go back to the town, and the town all of a sudden says, you know, these things that we've allowed you to do since June, at least June and July, the signs since October, now you can't do any of that stuff. You can't have, you know, a retail, you know, or, you know, an entity like that anymore. So, you know, at that time, it's the biggest part of my livelihood. So, you know, I signed it to try to stay operational. Then I go back to the state, and, you know, obviously this doesn't permit me to have the retail storefront, but you know, that's kind of what I'm appealing, is this, you know, this decision to restrict my rights with this document, when I feel like I should have been, you know, granted the rights that she had from the planning board application, which, you know, now constitute a retail storefront.
Yeah, I guess I'm not clear. I'm not sure I go along, you know, just that it's the same thing as a retail storefront, right? So, but let's kind of move just a little bit more into how this all, the sort of tail end of how it happened.
Sure. I just want, are you describing her business in the planning board application, or
Yeah.
the way that my business was allowed to operate?
No, I think her business would not, the way I read what she planned to do, if she did exactly what she said, that was not a retail storefront, that wouldn't have been shut down. But if she did more than that, then maybe, I just don't know what she did. But we're just talking about, again, as I'm trying to distinguish between what the planning board authorized her to do by granting her application, as distinguished from what she actually did. So I don't think you're saying, but tell me if I'm wrong. You're not saying that, you know, you should have gone to the planning board and applied yourself, or you're not saying that they didn't grant her, or you're not complaining that they granted her an application. You're just, so I'm trying, again, it's coming within the focus. We have just those things I laid out for you that we can deal with, and we can't like go beyond that. So I'm just trying to, so we're looking at something the planning board did wrong in not granting an application, or in granting an application if somebody opposes it. And the same thing with permits. You know, these are permits for the most part. You know, what permits should have been granted and weren't granted. And right now, I don't see any. I don't see the permits coming under the land use ordinance, in the sense that those are what you would need to operate the way she did. No, to operate the way she was authorized to operate was simply an application from the planning board. Then there would be the code enforcement officer would then come around sometimes and say, well, you're not operating in accordance with the planning board authorization or whatever. So I'm not sure we're arguing about a permit, or that this appeal is about a permit, but it could be. If you assume this is a permit, then, you know, you got the problem that you're too late, and we don't have any room for, you know, to change it. So you're too late if this is a permit. It looked to me like this was an attempt to agree so that you could continue in business and not have the state coming after you, and that you agreed to it. You thought that was better than getting shut down altogether. Let's say, I'm just speculating, but so you think of, so it's an agreement. Now, even so, if you're complaining, all right, I don't care what you call it, Russ, I'm complaining about it. So that's already over 30 days too. So, you know, it's like we don't have any room here. As I said to you before, I wanted to talk further with you to make sure that there weren't any other facts here or something that would change that. And so you're not complaining about the planning board, and that's the only action that's really happened other than this enforcement action, so to speak, the quasi enforcement action to which you agree.
I'm sorry, I'm having a hard time following you. I just keep hearing I tried to, I think I got most of what you were saying, but I'm hearing a lot of coughing and hacking.
Turn it off.
Like a water or something, or? Yeah, you have to hold that button down.
I have a question. Can I ask a question?
Yes, please.
So is there potentially, is the appellant potentially, and this could still be out of the time, this obviously could still be out of the time limit too, but is he potentially making a complaint or requesting us to look at the fact that the planning board failed to act, failed to give him written permission, right? I mean, is that potentially another avenue that he's, but the appellant seems to be.
Yes.
I mean, we haven't discussed that, but it seems, I guess that's a piece that I'm kind of
Yes.
unclear on. Was there a request to the planning board to grant written permission and it was denied? I guess I don't know where that whole, if that happened and how that happened and how that typically does happen and how those decisions are made. And then if that has happened, right, that's probably outside of the 30-day mark, but
Right. So Chris, did you ask the planning board, did you apply to the planning board for permission to operate whatever business you were going to operate there?
No, I was told it was a grandfather location, which was the reason I wasn't told I needed to make a planning board application.
Yep.
So I guess I
So is
I
that-
feel like I should have gotten permission to operate as she had at that point, which kind of ties into, this March 31st complaint. And the main reason I hadn't filed an appeal earlier is I was told by legal advice that I should wait until the new ordinance went through. I guess I wasn't aware that there was a 30-day limit on these things. Otherwise, I would have filed things much sooner.
Yeah.
And then I finally, before I filed this, I asked my lawyer, I said, I kind of got to get the ball rolling here. Summer's the best season and we're hoping to, if we can make any headway in this, we're hoping to have as much of the summer season as possible. So that's just as a side note, that's, the reason why it wasn't filed sooner.
Yeah, that's a shame. Now, do you have a copy of the new medical marijuana ordinance? Do you get one from the lawyer or see it on the town warrant or?
Yes, I've
Okay.
read it. Yes.
All right, good. Yeah, I mean, you can see you might think we could use that to interpret, but it wouldn't make too much difference. The time lapse is still there. But it only covers action or inaction, incorrect action taken under the medical marijuana ordinance, which none of what you described happened. It happened before that was adopted. So this is you in the town trying to work out how can you operate some kind of caregiver business at least during this period where there's no medical marijuana ordinance and where it's the only person that's really looking at as a matter of granting permission is the planning board. And then the planning board, we're just assuming that it's the fact that you were told.
I'm sorry. I'm
Missing it.
issue.
Can't hear. Okay. I'm trying to look at you and talk at the same time.
I'm so sorry.
Is this better?
Yeah, I'm so sorry. That last statement, I was just having some
Yeah.
static or something here for the connection. I don't mean to interrupt or anything.
No, that's
I just
okay.
wanted to
That's
let you
okay.
know I'm not hearing you, but I hear you now.
Okay, Chris, thanks. Feel like a cell phone ad. So I think you're not having problems with the planning board or what they authorized the predecessor to do. And you're saying that part's
No.
okay. The disconnect is that she was doing stuff differently from the planning board authorized her to do, and you thought that meant you could do it too. And so I think that's a challenge too. then, you still, then we kind of look at this, the letter and whether or not it's late, the appeal is late, right? So I'm just trying to go through the rest of it with you. So we got those pieces I mentioned, the limitations on what we have the right to look at. And if I can find it among all this paper, yeah, here it is. So we're back to, let's see if we can go down the list and see what we have here. So to reverse the decision of Mr. Stanley Waldeboro CEO in the letter of March 31 regarding the status of your marijuana business. So he's not making, if that's a decision, to me, it's like a settlement agreement that helps you get, enable you to get some, do some kind of business in the town there. But what's the decision that he's making? He's
To,
He's-
to,
go
sorry.
ahead. Yeah. no,
Well, I'm saying that decision, so yeah, just to go back one point.
Yeah.
Yeah, I basically, you could say that, yeah, I look at it like there's two definitions from the state. There's a caregiver retail storefront, and then there's an office, which is basically the definition of what a caregiver can do out of their home.
Okay.
I'm told, I'm appealing the fact that by today's definitions with the state, Renee was allowed at the location to have a retail storefront because of the sign, because of the hours, and the hours were also included in the planning board application. So I guess that's part of the appeal. But the meat of this appeal is that I was allowed to operate in ways which constitute a retail storefront since I established the business there by the CEO.
So Chris, let me ask you this.
Sure.
If the police are at your home and somebody comes in and robs it and they don't do anything, and then somebody comes in and robs it the next day and the police don't do anything, and then the same thing happens 5 days in a row and the police are watching this and they don't do anything, that doesn't mean it's not a crime, right? It's still a crime to rob you. So the fact that the enforcement is not 1,000%, just assuming that's the case here, doesn't mean it's okay.
No, it doesn't mean it. Sorry. No, it doesn't mean it's okay. But if you're, I guess if you're looking at that analogy, if the robber says, "Hey, I've talked to the police and the police said I can come in this front door," and then the police said, "Hey, you're allowed to say, hey, I'm John Doe and I'm going to rob this place,"
Yeah.
and then if you keep doing that over and over again, and the police say it's okay, but then all of a sudden on that fifth time, the police say, "Well, hey, you're not supposed to rob this place at all."
Yeah.
That's kind of more how I'm looking at it. Like, you know what I mean? It's that the police are making a mistake here. There's a mistake that's been made with how I don't like the analogy at all about robbing.
We could try something else.
Well, I think from Mr. Delano's perspective, my understanding is that he ordered his business and conducted his business and probably invested in his business and invested his time and his money and his efforts in something on reliance. From what he's saying, again, I wasn't at these conversations. I don't know exactly what happened, but conversations believing that he was running his storefront legally, and then it turned out that he wasn't. And he has, and then they entered into this agreement. I would consider this potentially, I would see that this would be a determination by the CEO, but then it was agreed to. So it seems like two steps as far as I would consider. There was a determination by the CEO, and then Mr. Delano agreed to it. From his perspective, it was just desperately just trying to keep his business open. But that's what I think he's saying, is that he kind of was in reliance on this, and now he has damages from it. But I think even with all of that said, is there any scope in which we can act as the planning board on any of this, because it's past this 30-day determination, decision, failure to act, any of those words? We're
Right.
past 30 days. Are we able to do anything?
May I maybe bring attention to something else which may provide further guidance on this matter. I'm looking at Maine Title 22, 2429D, which talks about local regulation and pursuant to the home rule authority granted under the Constitution of Maine, yada, yada. Anyway, it talks about how related to the state's medical marijuana requirements, that it says, among other things, a municipality may not prohibit or limit the number of registered caregivers, number one. Number two, it says that at the time this local regulation was enacted, that local municipalities couldn't prohibit existing caregiver retail stores from operating. But then it also goes on to say that municipalities could also not authorize additional caregiver retail stores and dispensaries and testing facilities and manufacturing facilities that were not already operating on the effective date of this section, unless the municipal legislative body had voted and adopted or amended an ordinance. So unfortunately, I think timing in this whole situation is critical, because as I understand it, Chris began his business around the summer, June, July of 2021. It sounds like this local regulation guidance provided by the state predated that. But it also was in this window where the town hadn't yet developed and approved its ordinance to provide further direction to people like Chris, right? And like all of us. So unfortunately, I think I'm hearing all of these, this information this evening. It sounds unfortunately like the previous owner here, this of this retail businesses, this Renee Grova, may have been operating in a manner that was different than the information she provided to the town when she obtained her permit. I mean, it actually, in these documents that she filled out at the time, which back in 2018, she specifically talks about the two retail operations, the businesses, one being, her farm stand, and the other being this wellness retail business, in which she specifically says that she's not going to be selling any products containing THC, but then goes on to describe this office in which she fulfills her marijuana caregiver role. But she specifically says that she in no way is going to become a marijuana dispenser. And so I think this is where there's a departure. Chris enters, he thinks he's taking over this business. How she was actually operating at that time, I don't know. I don't think it's clear to any of us that we could prove, specifically, conclusively, and causing then all of this confusion in terms of what Chris thinks he is being grandfathered in to be able to do, and what the town is telling him that, well, we just have to change the contact information on the permit because you're going to operate exactly as she did. So this is where the misunderstanding sort of arose. But then when you look at, okay, so what do we do about it at this point in time? We seem to be in this window now where we don't have an ordinance yet in effect. And I don't even know if at that time, if anyone figured any of this out at the time, whether the municipality had the authority to even grant Chris what he was seeking at that time. And then to complicate it further, which we haven't even talked about, but the ordinance that was approved, retroactive to April, only mentions, that there were two medical marijuana storefronts that were deemed to have been in operation and therefore grandfathered in, not three. So we haven't even talked about that.
Yeah, that's what I actually, I tried, I thought it was mentioned in previous moratoriums that there were those three businesses, those two businesses, and then the one at Cider Hill. I'm just looking at this. As far as just one point in that planning board application she submitted, it said that they're not a dispensary, or they don't dispense. With the state law, there are dispensaries, which before caregivers could have unlimited patients, we could only have 5 patients at a time. There were larger licenses given out to dispensaries, which would allow them to sell medicine to unlimited patients. I think that's what she mentioned in the planning board application. As far as when it said we're not a dispensary, I believe she was I mean, that's at least my thought on it was
Yeah,
that
and
she
to be,
was.
and to be honest, in going over all of this with a set of fresh eyes, because this is all a new territory for me, it's still even unclear to me, reading the main state requirements, how they distinguish between some of the activities of what's now being called a storefront versus a dispensary.
Yeah, and you see that's been a part of the confusion here as well. Is it was I was heard that you can't the municipality couldn't limit the activities of caregivers, and I thought that referred to caregivers operating out of their homes. I thought I've been under the the thought that I was allowed to set up at that location outside of my home because it was grandfathered there to be able to operate there and sell medicine to my patients. I thought that that's kind of part of the implicit sort of approval, that I felt I was given, to put that business, just to start the business there. And, we moved in immediately after Renee moved out. So there was no period where there wasn't an active caregiver business at the location. It's not like she moved out in, January 2021. Then we waited 5 months and then we moved in. It was back to back, so that was, I was told by Max as well that that's part of the reason why I was allowed to set up there and operate under this grandfathering.
Well, also in trying to read, again, the state's requirements around grandfathering, it also, I mean, again, I could be mistaken, but it seems like if you're a caregiver with a storefront, that allows you to conduct your business at that premises, and you can't kind of go and then do what you do in other locations. It's site specific. But then conversely, if the premise, so that the location is approved to be a storefront, and the caregiver leaves that location and another one enters that location, I mean, I am currently under the impression that too requires sort of a new permit.
Right.
But that's if we even go down that path.
Right.
But to your point, Russ, it sounded like Chris was originally granted, what he's appealing is the decision of the town that when he first came and he started his operation, he was told that he could continue to conduct business as Renee had conducted business.
No,
Authorized to conduct business. And in the paperwork that we've been provided, it's clear that she's basically saying, I'm going to use an office to see my patients, but my 2 retail businesses are separate. And that's what she was authorized to do. What she actually did and what Chris observed her doing and thought he was therefore able to do moving forward is where there's probably this big departure, right?
Sandy.
Well, as far as it being called an office, I mean, if I'm not mistaken, the other 2 businesses in town, Highbrow and Finest Kinds, I believe their planning board applications were written similarly. I know I didn't provide that material, but I believe it was said that they would have an office in that shared part of another business. Like, I believe Highbrow is a glass shop, and then there's a caregiver in the back in an office. I've been told by Jim York at the OMP that those are in fact retail caregiver storefronts. They're not offices, like they're a retail caregiver storefront because they're open during the hours that the other business that's in the same building was open. Therefore, they have advertised hours. And now through this new ordinance, they've been kind of, at least this is my understanding, they've been rolled over into now being accepted retail caregiver storefronts, even though in their planning board applications, they may not have been described as retail caregiver storefronts. After that law change in 2018, or that language was added, they're now defined as retail caregiver storefronts, but in their applications, they were simply a caregiver office in, a building, they which shared a building with another business. And that's what I was, that's part of, me looking at this, like, I didn't have to fill out the planning board application. Therefore, I assumed I was grandfathered after, for that unique use before the language that Renee had, which, you can say what you will about things that she was operating at the location. Like, I don't know. I'm kind of looking it over myself here, but I don't know if it says anything about a sign, but when she's talking about hours of operation to the state today, that constitutes a storefront, and that's in the planning board application. And that raises another question for me is if I was allowed, this is still a big question to me, is I feel like I was given half of the rights to operate as a retail caregiver storefront. And I guess in my opinion, I feel like if I was allowed, certain things that to the state are a retail caregiver storefront, that I don't think it's right or fair to my business to be denied everything when the state comes in, if I've been allowed, certain things by the state, by the town. Not to just kind of go on here, but anyway.
All right. So getting back to the issues that the relief here, a lot of it. So for example, we want, you're proposing that this board give you written approval by the town to operate as a medical marijuana caregiver storefront as one of the 3 grandfathered approved medical marijuana caregiver storefront locations in town. So we just don't have authority to do that, in that list I read out to you before. It's just not within our power. Our scope is just limited. If for example, we think the planning board did something wrong, then we say the planning board did something wrong, and it goes back to the planning board to fix it. We can't fix it. So.
Are you allowed to work on issues? I thought the other part of an appeal was decisions made by the CEO. Are you guys saying you have no power because of the?
No, I was just giving you that one example. So I'm just going down.
Yeah.
The ones that we have.
Okay.
So to reverse the decision of Stanley, let's do let's just get to that one. To reverse the decision of Mr. Stanley Waltz, Waldeboro Code Enforcement Officer, in his letter to appellant dated March 31, 2022. So that's the one where you've run out of time. But what would you, if we say revert, what do you mean? So we can't reverse it. We can say it's either right or wrong under the ordinance, but we can't like reverse it. So if we said it's wrong, if we said he acted not in accordance with the ordinance, I'm not saying you did, but if that's what we determined, then maybe the letter is unenforceable, but it's a letter agreement. So we can't unwind a letter agreement. That's not in our power either. So even if we said it was not consistent with the ordinance, it wouldn't unwind the letter. We can't do that. Now, why is his letter? What provisions in the ordinance, in the land use ordinance, is he not following? What about his decision violates the ordinance, the land use ordinance?
I'm not sure about I haven't studied the land use ordinance, but as far as, I'm not sure if this was in the state's law, but the part about municipalities not having the right to limit, is that the part about municipalities not having the right to limit the amount of caregivers, therefore me being allowed to have a caregiver business outside of my home. I'm not sure if that conflicts with the ordinance. I guess it's an appeal for his decision. I like was stated earlier, this was kind of like I signed this letter or I shut down my business. That's what it felt like. The state came in, Jim York was, let's just say, severe about how I could operate at the business. I've invested thousands of dollars and so much time into setting this business up. And, signed this letter to try to save the business. And then afterwards, after talking to, legal advice, I just don't think this decision was correct. This having to sign this letter to operate in the town, it's like, I'm not sure if I just shouldn't have had to sign anything to operate as they currently state I was allowed to operate. I just feel like this is, like I said, that's my view. That's my position in this is,
Yeah.
I felt like I needed to sign this letter to keep my business operating. I mean, in hindsight, it looks like it's almost like a moot point. It's almost irrelevant. This letter, I should have been allowed these things anyway without, this sort of letter to say this stuff. And this letter is even wrong as well, because it says you can only advertise online as a caregiver. It can only be one site with no hours. And that's a restriction of my rights as a caregiver. There's no, I don't think you guys can find any state law that says a caregiver can only operate on one site. This letter is just, it's just incorrect. And, the appeal is to cancel this letter, I guess, to avoid it. And, for me to be given those rights that I feel I should have been given, by being able to set up without a planning board application, as Renee Grover had. But I totally understand if you guys just don't have the power to do anything like that. I totally understand. I'm not sure if that's where you're getting at. Sounds like that's the conclusion you're kind of working towards.
Yeah, and we got the, the 30-day problem, and I feel badly for you on that, but we don't have any room on that either. We've just been trying to work it through with you on these other issues too, to see if anything can be helpful, but I'm afraid I don't see anything, Chris, myself, but
What I think that Mr. Delano is saying specifically is that the determination that Mr. Delano cannot have a storefront in Waldoboro because he is strictly a medical marijuana caregiver. I think that's what he's saying was incorrectly decided. And then specifically term number 6, he says, even if you correct that I can't have a storefront because of that I'm strictly a medical marijuana caregiver, and that whole analysis is wrong. But even so, even if that were to be correct, or whether it's correct or not, that number 6 would potentially limit, is not allowable under state law. It's not, I would say maybe he's saying it's not allowable. He said it's violation of his rights. I would say he's probably thinks it's a violation of his First Amendment right under the Maine and the United States Constitution to not be able to have more than one site. That's what it sounds like he's specifically saying. And I think that's after that, I do think we have these time limitations on top of it. But I think that would specifically be, let's say we were within the 30 days. That's what he's specifically asking us to overturn. And, it is the last term of that. And notwithstanding the entire determination that he can't have a storefront in the town of Waldoboro, that was incorrectly decided. And then we would have to decide, and then if we were within the 30 days, we would have to decide whether this is in fact a decision or a determination, or if this is a, agreed upon contract. And then even if it is, I don't know how that works, because If this is a contract, then what happens? I mean, can we insert ourselves within a contract or an agreement? And I would think we would have to get maybe municipal association or the town attorney involved to see, because I don't know if we have that ability to interfere with a contract. So I don't know. It seems like, but I think all of that is in one bucket. But the first question that we have is any of this within the scope of something that we can even start making decisions about? And I think because it's after the 30 days, I think
Right.
we're just out of luck to be able to even enter into those analyses.
So Chris, well, let me take, does everyone agree with that? That it's,
I think the key issue here is 30-day
Yeah.
appeals requirement.
Well, I mean, yeah, I mean, if we can't get beyond that issue, everything else we've talked about, it doesn't matter. And then if there's some way of getting around that, if we have the authority, which it doesn't seem that we do, but then if we are going to seriously look at some of the remedies here, it seems that everything in my mind goes back to whether the issue here is the argument should be that this was a third established retail storefront that should have been acknowledged within that ordinance that was subsequently approved. He's saying that, the former owner ran it as such. He took over, ran it as such. Everyone knew it was being run as such. And so it should have been acknowledged, and therefore it should have been, one of three. But unfortunately, the town never acknowledged his business as an established retail store.
That's absolutely the point I was trying to make.
And whether or not the town had knowledge it was actually operating as such or not on paper, it doesn't look to me like the town knew it had not approved or authorized it to be run as such. Whether any officials in the town knew it was operating that way, it would have to be proven, I suppose, to go further. If we are even able to do that, and if it's the 30 days, so.
So is there a possibility in the future, if I somehow can get this letter, invalidated, that I would be able to bring this issue before the appeal board within 30 days of having this letter canceled or voided as a violation of my rights? Is that something which would be within the planning board's power to work on? Is that in your scope, your guys' scope of what you do?
well, you said you've got legal counsel. Can you have her or him just show you those provisions I mentioned, as to what the scope of our jurisdiction is? And just in case you didn't write it down, let me get what those were. Okay. Or you can look them up too, because it's online,
Yeah.
So Chris, it's 5.1.4.1. That's first one. Second one, 5.1.4.2.
Okay.
All right, now there's several, three more.
Sure. 1 sec. I'm typing this down.
Okay.
5.1.4.2.
Yep.
Yep.
5.1.4.3.
Okay.
And then 5.2.1.
Okay.
All right, now that's in the land use ordinance, which is what all this is about, but there might be something you and your lawyer can be thinking about under how to proceed even under the medical marijuana one that's been passed now, right? So and the appeals or jurisdiction there is 4.7 under the medical marijuana ordinance. Because it could be there's different ways for you to approach this, I would think, but we can't since it's past the 30 days, then we don't really have we can't consider it. We have to, but you know, you heard me read that thing.
If the town or the CEO or the planning board make a decision or refrain from acting in something that was in their scope of action, or if it's all kind of detailed in those, in what you just referenced, but the town would, the planning board or the CEO would have to do something or fail to do something, basically.
Right.
And so that's where we're gonna be with any of this likely, but that is certainly something to speak with your lawyer about other avenues. But we're here if it's within our scope, and you can appeal a decision or an inaction or anything like that, then we will be here.
Yeah, so Chris, just to remind you, you can appeal this decision if you want to the Superior Court, right, within 45 days of today, because we're giving you the decision now that we don't, that the 30 days has passed, so we don't have any, we can't consider it because it's passed.
Am I gonna, am I going to get a kind of a written summary of some
Yes,
sort?
we'll give you a
Okay.
decision. Yeah, we have to write the decision, but I'm just telling you what, you know.
Yeah,
from- yeah, yeah.
okay. Okay, well, hey, I appreciate all your guys' time tonight, and thank you, Max, as well. I don't, you're not on camera, but I'm assuming you're running the Zoom meeting. Thank you guys for your time.
All right, thanks,
Thank
Chris.
you.
Take care.
Oh,
You have to vote.
oh, yeah.
Oh.
Good to vote on record.
Sure, so we vote.
Make a motion.
I move that that the planning board doesn't have authority to act in this matter.
Board of Appeals.
I'm sorry. I just demoted us to the planning board now. So yes, the Board of Appeals doesn't have authority to act on this petition.
Because it wasn't timely filed.
Yes, because it was filed past the 30-day requirement.
Second,
Second.
all in favor? Aye. Opposed? Passed. Okay. Any other business?